Guys, chapter 9, this is our last chapter of contract law, all right? And trust me, we could discuss so much more on contracts. Contracts in law school was a 2-semester course for me, just contracts alone. And actually, after those 2 semesters, I think that they only scratched the surface. You can only imagine what having 3 chapters in an undergraduate textbook does. Again, it provides you just a very brief summary of the issues that are going to arise when you're dealing with contracts. But that brief summary is going to have potentially huge benefits to you if you internalize, if you remember the lessons that you're learning here. This is why you're taking this course. More than anything else, you're trying to learn about what the legal ramifications, the legal consequences are, what you should do legally. You have to consider it, because business goes hand in hand with the law. We don't live in a country without laws with regard to business transactions. Arguably, some people might like that idea, but generally speaking, most people believe that without the laws, it would result in complete chaos to both business owners as well as to citizens. So anyway, let's move on to chapter 9, and we start talking about termination and enforcement of contracts. Once again, you get a hypothetical, this time involving Janet and Alfonso Owens. Please read over that hypothetical. All right, being able to relate to that hypothetical involving the Owenses is going to help you better understand the concepts that we're discussing in this chapter. We talk about terminations of contracts. How do you terminate a contract? They give you, on page 196, 4 bullet points. This is how you do it. You can do it through performance, full performance. Both sides have done what they've said, everything's done, everybody walks away happy, case is over, event is over, performance. It's a natural way to end, and most contracts obviously will end that way, with both parties walking away, at the very least semi-satisfied with the service provided by the other. Through agreement. By agreement, you can say, okay, we are going to end the contract this way. And in fact, the contract may even spell out that in order to terminate what would otherwise be a continuing contract, that the parties can come together and end the contract by mutual agreement, or even under certain cases, unilateral agreement, meaning one party has the power to say, we're done. Through frustration. And this is an important doctrine. All right, due to unforeseen circumstances, the point of the entire contract is completely undermined. So say that you're trying to get a supply of apples, and you're trying to transport them from one point in Nova Scotia to another point either in Nova Scotia or outside of Nova Scotia. And there's a contract with a farm for you to be able to actually move those apples. And then what happens? Well, there's a plague. There is a natural event, whether it could be a hurricane or it could be the earlier winter snowstorm that wiped out several trees. And are you going to be able to actually transport? And are you out business from it? Yeah, you are. But was it the other side's fault that you're actually out this business? And the answer is no. The very purpose for which you have contracted has been completely undermined, has been completely frustrated. So that's another way for you to actually terminate a contract. The other way to terminate a contract is what we've been discussing. By breaching the contract, by violating the contract. So you have 4 different major ways to actually terminate a contract: performance, agreement, frustration, and breach. All right? And the book goes on to discuss each one of them. And so rather than belabor it, I'm just going to simply say termination through performance we've already discussed. Whether it's through you or whether it's through others, that performance extends out to you. There's this notion that's discussed about vicarious performance, meaning that you have an employee or you have a subcontractor, somebody else who you contract with to fulfill it. If that subcontractor does not fulfill the purpose of the original contract, then you are also what they call vicariously liable. You are responsible for what somebody who you designate to complete has done, whether it be your employee or whether it be an independent contractor who you contract with to actually complete performance. Termination by agreement of the parties. So we turn to page 197 and those 4 bullet points that deal with termination of the agreement by agreement of the parties. Termination of the agreement by agreement of the parties. And you'll see from those 4 bullet points, you can enter into a whole new contract, the novation, as we've just discussed. You can vary certain terms of the contract by mutual consent of the parties, so that it creates at least a different contract than what originally existed. You can end the contract. You know what? This isn't working for us. We need to move on. Let's end our contractual relationship. And last, by substituting a party. You can have the original contract, but you can then assign those contractual obligations to somebody else. A good example might be if you rent an apartment right now and you no longer want to rent the apartment. Whether you're graduating from university, whether you found a cool new roommate, whether you're moving in with a significant other, you can try to sublet your apartment to somebody else. You can assign those obligations to somebody else. So long as your landlord agrees to that, then the original lease can continue on by substituting parties to that agreement. You can also, as I mentioned, transfer contractual rights by way of assignment. All right, and you'll see the definition of assignment on page 198. The transfer of a right by an assignor to an assignee. If you're the original tenant in the apartment, and you want to assign your rights to live in that apartment to somebody else, you are the assignor. The party to whom you're assigning those rights to live in that apartment is the assignee. That's the most common example, and you have the ability to do that. Look at figure 9.1, which lays out the steps in an assignment. Step 1, a creditor-debtor relationship. Contract is entered between C and D, whereby D owes money to C for services rendered. That's a creditor-debtor relationship. They have step 2, assignor-assignee relationship. Contract is entered between C and A, whereby C assigns the debt he is owed to D. And then last, step 3, the assignee-debtor relationship. All right, so long as the assignee gives notice to the debtor, then the debtor is now obligated to pay directly to A. Now, what does that all mean? Because that, to me, would sound, if I was sitting there right now on the other end of the computer, to be a whole bunch of gobbledygook. All right? In this particular case, they're talking about assigning debts. So they're talking about one particular person or one particular company assigning a debt to another person. Oftentimes you see this with collection agencies. So say that you owe MasterCard or Visa or American Express a certain amount of money and you failed to pay on that money. Then Visa, MasterCard, American Express could eventually, if they can't get you to pay themselves, then they may assign it to a third-party debt collection outfit to actually do the collection. They assign the debt in the hopes that they can collect something from this other party, and then the debt collection agency can collect from you. They have the right to, under the contract they have with you, assign the debt to others. It's almost like also a mortgage. All of a sudden you might find that your mortgage is no longer with this particular bank, but it's now with another particular bank, because the bank reserves the option of simply selling off your mortgage to another bank. Termination by frustration, I think we've discussed, but you'll see what the elements of frustration are right down there at the bottom of page 199. Frustration needs to be unforeseen. It can arise due to the fault of the parties. It makes the purpose of the contract either impossible or drastically more difficult to achieve. And finally, it can't be a risk the occurrence of which was contractually allocated to either of the parties. Meaning, of course, that it can't be something that either party could have, should have anticipated naturally. And some contracts might, especially when you're talking about agricultural products, some contracts might actually anticipate what happens in the event that there is an act of God that occurs that makes the contract all but impossible to actually perform. But these are the 4 major elements of termination by frustration. And you'll see, getting into act of God on page 200, this notion of force majeure at the bottom of page 200. Force majeure is an act of God. It's an act of nature. And these force of God clauses, these force majeure clauses are common. They're boilerplate in most contracts. You want to put them in there, of course, because you don't want to later be held accountable in the event that a hurricane or a snowstorm or an earthquake or a tornado or a typhoon or name the natural act, a major fire, comes and makes it virtually impossible for you to be able to perform under the contract. Enforcement of contracts. Okay, a contract has ended, or a contract has been breached. How do you go about enforcing the terms of a contract? There are three primary things that you need to prove before a court in order to be able for the court to hopefully vindicate your rights, to enforce the terms of the contract on the party that has breached the contract. And the standard is by balance of probabilities, all right? And we may have discussed this a long while back. In these types of civil cases, it's always based upon what I call the preponderance of evidence test, or the balance of probabilities test. It means the same exact thing. Pretend that you have a scale, and each side is balanced out. And you go in there thinking, okay, this is where we sit when we enter into the case. Is the burden on the plaintiff to actually attempt to prove their case and to tip the scales more in the plaintiff's favor and over and above the defendant's favor, the breaching party's favor. So long as the balance of probabilities is satisfied, it could be 51-49 when it's decided by judge or jury, but whoever gets the balance of probabilities tipped in their favor is going to win the case. The plaintiff has got to show that there is privity of contract. They have to establish that there is a contract between the parties and that the parties intended to actually enter into a contract. They have to show that there is a breach, that there has been a violation where one party has violated a promise or term of that contract. And last, and this is so important, the plaintiff is going to have to establish whether they're entitled to a remedy. They have to show, okay, the other side breached the contract. And they were, there was privity of contract. You guys obviously intended on actually entering into a contract. Okay, that's great. What's the remedy supposed to be? Are you even entitled to a remedy? And this is sometimes, you have to understand, when lawyers go into cases, including myself, okay, it's not that hard for us to prove the breach, believe it or not. It's the most challenging thing is showing entitlement to a remedy, and if so, what type of remedy? What are we going to get out of it? And that can be difficult. And trying to assess an amount for damages, if your client is entitled to damages for the breach, being able to assess the amount is not an easy thing sometimes. Sometimes it's okay. Sometimes it is easy to assess. Other times it's simply not. Let's start with privity. All right, privity, critical concept. Critical just as much as the other concepts I've mentioned throughout this course that I put a stress on. All right, and even the book says that it is a critical concept, because without privity of contract, you have no right to go to court. You have no right to enforce anything. You have to show that there is a direct contractual relationship between you and the other party. How do you go about enforcing a contract if it's not directly between you and someone else? And you can find situations to say, okay, maybe the contract was between your child or your brother or your sister or somebody else or your close friend. Can you go about trying to enforce another person's rights against the breaching party? Sometimes you can, depending upon what's actually in the contract, to protect those rights in the event that something happens to one party or the other. Next, we come to actual breach of contract and how you classify a breach. All right, and you'll see that they have three important critical terms. A condition is an important term that, if breached, gives the innocent party the right to terminate the contract and to collect damages. And then we get into this notion of a warranty. All right, it's a minor term that, if breached, gives the innocent party the right to only claim damages. All right, so say that you have a warranty. You purchased a cell phone. And that cell phone normally comes with a warranty, a limited warranty. What rights do you have under the warranty? Say that cell phone breaks within the first 12 hours of you purchasing it. What are your rights under the warranty? The warranty may provide that you can come back and get your money back. The warranty may provide that the company will replace it free of charge. The warranty may say, we'll repair certain things, but you're going to have to pay for the rest, and you're on the hook for the rest. The only thing that you have a right to, you can't necessarily cancel a contract with a warranty, but you can receive damages for what you're out because of those defects. And a warranty is limited to far more, the purchasing of some type of consumer product like a cell phone. The last term that they define on page 204 is an innominate term. It's a term that cannot be easily classified as either a condition or a warranty. We're not going to go into that in any way. Please note it, but again, I'm not going to be assigning or testing on that. One type of clause that you see often in contracts, especially contracts where you have had no role in the actual drafting of the contract, whether it be a consumer-based contract or whether it's your Facebook terms and conditions, you'll oftentimes find that there is some type of limitation on liability, where Facebook doesn't want to be sued, and if they're going to be sued, they can only be sued under certain circumstances, and normally, as I said earlier in the course, they're going to want to arbitrate those claims. However, courts are extremely, extremely reluctant. They're hesitant to actually enforce those types of liability limitation clauses when it involves a fundamental breach. Okay, and you'll see fundamental breach defined on page 205. It's a breach that affects the very foundation of the contract. If what has happened is so fundamental to the contract, then why, as a matter of public policy, would a court normally enforce something like that? Because all it would do, effectively, is it would encourage the breaching party to continue to engage in that type of a breach. And as a matter of law, as a matter of public policy, the courts are very, very, very reluctant to actually try to enforce any type of such clause if it's only going to allow for one party to get away with something just short of murder. You'll note on page 207 they define this notion of anticipatory breach, where you know that the other side's going to breach anyway, so you breach and try to get out of the contract in order to in some way limit your harm. And then we get, on the bottom of page 207, we get into this notion of remedies. Remedies is a whole course in and of itself, and it deals specifically with, okay, what can you get back for being harmed by this breach of contract? First thing, of course, they define are damages. You'll see that on the bottom of page 207, and it's pretty self-explanatory. Damages generally involve monetary compensation. You're going to get money if the breach falls in a certain way. There's also this notion of what the measure of damages is going to be, whether or not you're going to get expectation damages, or whether or not you're just simply going to get whatever puts you back in the position of where you would have been but for the actual breach. And it depends. Will expectation damages make you more than equal? Will they give you something more than what you're otherwise entitled to? Because effectively, a lawsuit is not designed normally to increase your benefits under a contract. It's designed to put you simply back at where you would have been otherwise. Expectation damages might actually do that, or it might not. We also get into this notion of punitive damages, which I've mentioned a couple of times in this course. This notion of punishment damages. It requires normally for there to be an intentional act. If there is an intentional breach of contract, then punitive damages are a possible remedy. And yes, that goes well beyond simply compensating you for what money you're out. It goes into literally trying to send a signal to the other side of that breach and say, this breach is so bad and your conduct is so poor that we're going to punish you for that in order to make an example out of you, in order to deter, in order to try to prevent these types of breaches from occurring in the future. If you'll turn to page 212, we get into this notion of a duty to mitigate. You have an obligation, even if you've been victimized by someone breaching a contract, you have the obligation to take reasonable steps to minimize your losses resulting from a breach of contract or another wrong. Again, perhaps the best example is going to be coming down, for students at least, coming down to an apartment lease. Say that you're 6 months into a 12-month lease, and you have no reason, you're satisfied with the apartment, the landlord's treated you fairly, everything's good, but you decide that, you know what? I think I could do even better in a different place. Maybe I can get a couple of free extra months, so you leave. You walk away from your lease on your apartment halfway through it. Now, does the landlord, as a result of that, can the landlord sit on that for another 6 months, not try to rent out the apartment again, and then claim that you owe all 6 remaining months to him or her? And the answer is no. The landlord has a duty to mitigate, to try to mitigate. The landlord has to make an effort. If you leave and you have 6 months left, the landlord has to try to re-rent your apartment out. So long as they're taking reasonable steps to rent it out, then they can claim the full measure of damages if they don't rent it out again after 6 months. However, there's a strong likelihood that that landlord might be able to rent it out in 2 or 3 months and limit the harm to the landlord. If they fail to do that, then the court's not going to give them a full set of damages for your breach. They're going to try to limit it and say, okay, how long reasonably would it have taken to actually re-rent this apartment? If the landlord can't show that they tried to mitigate, they're not going to get everything. We also talk about this notion, and it's important, and I'm going to really stress this, page 212 through 214, dealing with equitable remedies. We're not talking about money damages right now. We're talking about other types of remedies that could be exercised. And there are at least 3 key ones, from specific performance to an injunction, to rescission, and the last one, restitution. So there are actually 4 different ones. And let's talk about those because this is the end of chapter 9. First, specific performance. Okay, guys, specific performance is a rare equitable remedy. It has to be a truly unique situation where the breach cannot in any other way be remedied by awarding damages. You're effectively forcing the breaching party to perform their contract because of the uniqueness of the situation. They give some examples of how courts will oftentimes avoid imposing specific performance on a breaching party, whether it's because of the improper behavior perhaps of the plaintiff, or delay, or impossibility, or because of severe hardship in specifically performing, or because if it's an issue involving employment contracts. Specific performance is so rare, but yet it is an equitable remedy. Court looks at it and says, okay, what can we do to make this right under our equitable powers, our powers that exist independent of whatever the law might say, to make things better for both sides, or to at the very least make it right for the person who is the victim of the breach. An injunction. An injunction is something that is designed to cut off activity, to prevent certain activity from continuing, or if it's imminent, it's definitely going to happen, to prevent it from starting at all. And a court has the ability to award injunctive relief against one side in order to prevent a continuation of the breach. The next one is rescission. Rescission is very much like specific performance. We talked about rescission earlier in Chapter 8 in the context of misrepresentations and mistakes. However, in this particular case, just like specific performance, courts are normally reluctant to actually impose rescission unless they feel that it is the only equitable method to actually making the plaintiff, the victimized party, whole. And finally, we come to restitution. Restitution can be broken down into 2 separate areas. All right, one is unjust enrichment. You'll see it defined there in the left-hand panel of page 214. Occurs when one party has undeservedly or unjustly secured a benefit at the other party's expense. Let's talk about unjust enrichment for a minute. I'll give you a recent example where I was actually in trial. I had one circumstance where I was recently in trial where the party had moved on. My clients had moved on to a particular piece of land with a promise that they actually are going to be able to purchase that land in a certain period of time. When they got onto that land, they improved the land itself and they made it into a new home for themselves. After a couple of years, they learned that the land, despite the fact that they'd moved onto it, they'd made all these improvements, that the land was not going to be sold to them, and that they were going to be forced to leave the land and leave all the improvements right there. They left the land, ended up purchasing a different piece of property for more money. The person who owned the original land that they had moved on to had the benefit of all the improvements to the land. Is that fair? And I brought the action to court claiming unjust enrichment. That the party who victimized my clients had no right to have that type of reward because of their dishonesty toward my clients. And you make that argument and you say, okay, how much has the other side been unjustly enriched? And you make the argument and you try to prove up exactly how much your clients are entitled to once you can show that there was actually, at the very least, a breach of a promise. There wasn't a sale of land in this case, such as to require the statute of frauds to be involved, like we discussed previously, but it's a promise to allow for the purchase of land in the future. And the court listened to it and heard about approximately $20,000 worth of damage to my clients because they had moved someplace in good faith and they had made these improvements and now they were leaving that property and moving on to a different property. All the money that they spent to improve the property, aren't they entitled to that back? That's the argument in an unjust enrichment claim, which is essentially a form of restitution. The second type of restitution is called restitutionary quantum meruit. It's an amount that is reasonable given the benefit the plaintiff has conferred. It has to be a reasonable amount, and there's no exactness to it. You don't know necessarily if it's exactly the right amount down to the last dollar or the last penny. All right, it's the court trying to say, okay, how much is this person reasonably entitled to in order to once again make them whole? So, guys, that ends chapter 9. As you've seen, we've dealt with the termination of contracts and we've dealt with the enforcement of contracts. Alongside the enforcement of contracts, we've actually dealt with the issue of remedies. All right, and once again, you're going to have remedies that involve damages, and you're going to have remedies that involve equitable relief, such as what we've just ended discussion of: specific performance, restitution, rescission, and injunctions. All right, we're going to move on to the next chapter right now.